Software as a service agreement. What do these agreements cover? When are they relevant and appropriate? And what are some of the main sections we see in a software as a service agreement, otherwise known as an SaaS agreement? In today's video, we're going to be talking about all of those questions and we'll be answering them one by one, of course, with the bulk of the video spent on specific clauses we see in an SaaS agreement. As individuals and companies become more creative with the services that they provide and also the services that you as a small business owner or entrepreneur might rely on from these other companies, it is all the more important that we understand what's really going on with a software as a service agreement. In terms of what software as a service even means, conventionally what we're looking at here is a scenario whereby a company has either created its own software or a company is licensing a type of software from another owner company and then allowing users, which would be you as a customer in this case, to access that software, to benefit from that software. So the service that you are being provided with is inherently here the software piece, right? And that's important because this is relatively new developments in the contractual world, in the business world, in the legal world, all of that. So far, service agreements had captured conventional physical delivery of goods, for example, and much more commonly understood service delivery models. Software as a service is a new model of delivering services because so many of these softwares that we rely on are new. And what are we talking about, by the way? What are some examples? We mentioned in the video we'd go for examples. You probably already use these companies if you're a business owner, and especially if you're a business owner whose company, is on the larger, more sophisticated, more involved side of business. One software as a service company is Google Workspace. Another one is Salesforce, which is, instrumental to the delivery of business models for many, many large corporations. And as the name indicates, many large corporations that are themselves involved in selling something, whether it be life insurance companies are using Salesforce, whether it be subscription services, magazines, whatever, legal services, whatever the case may be, a lot of larger companies use Salesforce. One software as a service company that you don't need to be big at all to use, you can individually and personally use it, is Dropbox. Dropbox is a software as a service company. These are all examples. Maybe now is a good time in the video to take a second and let you know who I am and why I'm qualified to talk about something like this. My name is Pamela Metani. I'm a business lawyer and business owner myself. As an entrepreneur, I have various companies that I operate. And of course, the one that you're looking at here is Graphene Business Law, a law firm operating virtually and throughout the province of Ontario, Canada, providing services exclusively to business owners and entrepreneurs. If you're new to our channel, you're going to want to click like on this video and click subscribe. Most people that are watching these videos have not yet subscribed. So be a good one and click subscribe. It takes a lot of time and effort to put these videos out there. And again, as you'll notice, we put free educational content that's most relevant to business owners and entrepreneurs multiple times a week out on this channel. Now, as we discussed earlier in the video, we already covered sort of what SaaS means. We talked about some examples so that you better understand, well, who's actually doing this. Although doesn't have to be large players. I have clients and companies of like 2-3 people that are delivering software as a service. It can be anybody, and that's why a video like this is necessary to watch and understand, because that landscape is evolving so quickly and there's so much ingenuity surrounding the software world right now more than ever. It's growing and growing and growing. As I mentioned in the beginning, the biggest section of this video would be talking about the sections themselves. So what do we actually see in a software as a service agreement? It goes without saying, we're going to see some sections there about who the parties are, who's contracting, what jurisdiction they're contracting in, what are the governing laws. So if you're a company in Toronto, Ontario, and then there's another company in Albany, New York, well, you're kind of not only in different states and provinces, but different countries. So whose law will govern if there's a dispute, if there's an issue, or just for regular regulatory purposes. Also the term, are you signing up for a contract that is forever, in perpetuity? Are you signing up for an annual contract? Are you signing up on a month-to-month? Those sections are like necessities, and of course they're important because we need to know who the parties are, but the sections that really pile on in a software as a service agreement would include something, for example, such as each party's responsibilities, okay? So if you are the one providing the service, which in this case is software, what are the responsibilities expected of you? Not just on a good day, but what can the customer expect of you when your software crashes? What can the customer expect from you when there's been a data breach? And obviously that is of significant importance to them as a customer, but also to you from a reputational perspective, operational perspective, and all that. What are the customer responsibilities? An obvious one better include that they pay their bills on time, but also you'd want things in there about, you know, how they're going to be using your software appropriately. And speaking of services, by the way, well, there's gonna be a section in there, or there should be a section in there about what service are you actually offering. We don't want to put here, you know, 32 different things that you do on a daily basis. Like this isn't, you know, I put the comma, dot the I, cross the T. This is like the big picture, the kind of services you're advertising on your website as delivering, for example. So the services that a customer wouldn't sign up with you if you weren't delivering, and services that a customer genuinely can expect you to deliver every single day, every single minute of that contract. There's also going to be a representations and warranty section. And how this section differs from responsibilities is that responsibilities might be something that governs your daily operations, okay? But representations and warranties oftentimes can be statements made that the parties make to each other in order to enter the contract. So you would, and hopefully can and should, represent and warrant as a company, if you're on the software company side of things, that, you know, if you're saying you own the product, that you actually own the product. If you are saying you're competent, that you actually have the requisite competence to deliver this product to or a service to a paying customer, right? On the customer side, you'd want to represent and warrant certain items as well, but again, these being the really big picture items, that you won't conduct yourself in any unlawful sort of manner, or that you, on the flip side of that, will conduct yourself appropriately at all times, including X, Y, Z, whatever sort of conduct that you two parties are comfortable agreeing with and deeming as genuinely appropriate conduct for the duration of this contract. A mega section we see in software as a service agreements, as you might be like waiting to hear, is the confidentiality sections, okay, and the intellectual property sections. Sometimes you see these merged into one, but it would become like this mega section, like many pages long. Other times they're broken up. As a lawyer, I personally like to break them up because there's so much content, it's so much to digest. But confidentiality is huge. I mean, in the software world, like there's literally nothing you can touch. So everything we're doing, we are doing it on the good faith that this is going to stay confidential and appropriate and all of that. And when it comes to confidentiality and intellectual property sections, please consult a lawyer, okay? I'm telling you that these clauses need to go in the agreement, but there's no way I can advise you over the internet without having met you, without you retaining me as a lawyer, without knowing your circumstances and being able to properly protect you as to what to include in a confidentiality section, like word by word on an intellectual property section. I'm telling you it's there and that you need to look out for it. And then whenever you see a lawyer, including us here at Graphene Business Law, you ask the questions of, well, what does this really mean and how am I protected in this confidentiality or in this IP section, okay? So again, giving you the knowledge required to keep an ear out and poke when it comes to these super important sections. Another section that we kind of touched on is going to be the fees and payment, but that's important because with software as a service, sometimes payments can be on odd payment terms. Okay, so it can be a flat fee of something, it can be a percentage of the income that you're expecting a customer will bring in. It can be billed monthly, bi-weekly, annually, it could be an annual software as a service fee. So this can become tricky as well, but big picture, obviously this isn't one you should leave the table without discussing and making sure it's in your favor. And that's of course the dollars and cents, okay? Payment. If you're the service provider, what's in it for you? Money. If you're the customer, well, what are you gonna give in order to attain access to that software? Money, okay? And you come to a mutually agreeable upon point in that agreement. There's going to be other sections we see in these agreements, including, insurance sections. Goes without saying, all parties ever to any contract should be insured. Why wouldn't you be? And you should not agree to be in business with somebody that's not holding themselves out to be insured. There's going to be sections on if something terminates, what way do we go about it? If service needs to be suspended, on what circumstances? Because you should know, as a customer, for example, you shouldn't log in, with a client on the phone sort of thing and be like, oops, my page isn't refreshing. Well, come to find you didn't pay your bill on time, you were late by like a day or two, so your service was suspended. What does that trigger for you? How can you unsuspend? How can you get back? If you are terminating the agreement altogether, well, what does it look like for that software company to hand you back what is known as data sets or customer data? Like, arguably you've inputted a lot of confidential information into their software setup, again, whether they own or are licensing the software. So how do you get that back? And if you are on the software side of it, the company side of it, obviously, like, why would you want to keep this information other than data mining and nefarious things like that? But arguably the customer wouldn't have agreed for you to do that to their data in the first place. So what are the terms you are to be held against in terms of you delivering certain data sets back, okay? There's going to be other sections. I mean, there could be like 20 sections or 100 sections that go into a software as a service agreement. But the point of this video is not to talk about like each single comma and, the severability clauses and the arbitration clauses or dispute resolution clauses, things like that. The point is to educate somebody that's considering entering into such an agreement from either direction, either as a software provider or as a customer, to give them an understanding of generally what the main sections of such agreements are and what you should be looking out for, and starting to think and even do a little bit of research yourself, not in the legally binding sense, but research as in like educational research on what you should be advocating for yourself, so that when you do make it to that meeting with a lawyer, you can have the most efficient conversation possible about how are your rights being protected through this software as a service agreement. If you've watched this video so far, thank you so much for watching. Let us know, are you a type of company that's providing software as a service? Have you entered into one as a customer? How is that going for you? What were sections that you were confused about when you signed, or what were sections that you found particularly interesting in what was likely a fairly long agreement? Okay, and what do you think other small business owners should look out for? We do have a little bit of a community here, Graphene Business Law's YouTube channel, and everybody loves to hear firsthand lived experience, commentary, myself as a lawyer included. So let us know. If you are looking for legal services in any of the areas covered in this video, of course you can contact us within the jurisdiction of Ontario, Canada. Our website is graphenebusinesslaw.ca and our email is info@graphenebusinesslaw.ca. And with that, thank you for watching.